Okay, hello everyone. This is just a little summary about the jury, just based on your pre-assessment, some things that you might want to review and just are noteworthy to go over a little bit more. Okay, so we're right now in Unit 6, which Unit 6 is about the criminal trial, and in this unit we will be looking at the trial jury or the petit jury. Okay, a petit jury determines guilt or innocence at trial. A petit jury does not have to be made up of 12 people, okay? So there could be 8, there could be 7, there could be 11. Especially in a criminal trial, it doesn't really matter if it's even numbers. It could be an odd number because everybody has to have the same verdict in a criminal trial. Okay, but the Supreme Court has determined that the minimum number for a petit jury must be 6. Okay, so there has to be at least 6. So sometimes at the county court level, which is usually a lower level court, you may only have 6 people on the jury versus 12 if it's a felony or something. Okay. In Texas, all criminal petit juries must have a unanimous verdict. So what does that mean? That means that everyone must agree on one verdict. So if someone's going to be found not guilty, everybody on the jury has to say not guilty. If someone's going to be found guilty, then everybody on the jury has to say guilty. Otherwise, it's called a hung jury, which meaning that everyone didn't have the same verdict. And in that case, then the prosecution, which is the attorney that works for the government, they can choose to retry the case again. So it's not double jeopardy because there wasn't really an end to the case, because it has to end in being found guilty or not guilty. So there's no way for it to end in it being, in between. Okay. Now, civil court is different. Civil court, you don't have to have a unanimous verdict. You just have to have a majority. And, of course, that'll depend on the size of your jury. But in criminal court in the state of Texas, everybody has to agree. So it has to be a unanimous verdict. Okay? So some of y'all thought unanimous means that someone is anonymous. You don't know their identity, but that's not what it means. Unanimous means all agree. Okay? So when you're starting to look at the jury selection process, it begins with sending out notices to appear for jury duty. So you get like a little postcard. It looks, could be a little bit bigger than this, okay? But you get a postcard in the mail with your name telling you a date to report to the courthouse and which court to report to, okay? So this is based on the master jury list. And a master jury list is a long list of names, long list of names that comes from primarily voter registrations and driver's license. Okay, so that's usually, and that's how sometimes people who are under the age of 18 end up getting a summons because maybe they got it because they have a driver's license. And so it ends up that they'll get a summons. But of course, if you're under the age of 18, you already have an excuse and you don't have to report for jury duty, but you do have to notify them that you are under the age of 18. And on the back of your jury summons, it gives you a way to notify the court that you have an excuse, an exemption to jury duty. Okay. From there, once you have gotten the postcard, then there is a veneer is formed. And a veneer is basically just a potential pool of jurors. So it's just whoever is going to be your group, because the master jury list is everybody who has the potential to be called. And then the people that actually get the postcard and show up, that's your veneer. Okay. Those who report to the courthouse will go through the voir dire process. And basically, that's a series of questions to find the best juror for that particular case. Now, if you're in the veneer, you're a potential juror, you haven't been selected yet, you won't know what the case is, but the attorneys will. And so they will use the information that they get from you through perhaps a questionnaire. If it's a felony case, you're definitely going to probably fill out a questionnaire first. And then from there, you may be excused just based off the answers that you gave to your questionnaire. Okay. So you may be excused based off of that. If not, and you make it through to the second stage, which is where you're actually in a courtroom, conference room, someplace, and attorneys are actually asking you questions. That's also part of the voir dire process, where they get to ask you questions, the defense and the prosecutor, to figure out if you are going to be a good juror for the case. Okay. When they're doing the questions and they strike or eliminate a juror, they do so through two different ways. One is the challenge for cause. And the challenge for cause is based on that person having some sort of bias. Not that you suspect, but that you have some sort of evidence that they have bias, whether it be because someone shows up with a shirt saying, free rape is, just a way to get extra love or something like that, and it's a rape case. Well, you don't want that person who seems like they're pro-rape on your rape case. So that is a bias that they have just based on the fact that they have that shirt on. Okay. Sometimes it may be how the person answers a question, where you're able to identify, hey, this person may have some sort of bias in this case. And in that case, then you can use a challenge for cause. You get unlimited numbers. Each attorney gets unlimited numbers of challenge for cause, but they do have to have the judge's approval. So if they say, hey, judge, I want to strike this person challenge for cause because, and the judge will say, yes, I agree, or no, okay? Then the next one is peremptory challenge. And a peremptory challenge, this is the ones where the attorneys don't have to explain to the judge why they're using a peremptory challenge, but they do have a limited number of peremptory challenges, but they don't have to explain those. When you're using a peremptory challenge, you have to make sure that you're not wanting to strike someone based on their race or their gender. Of course, if you really think about it and you're not really having to explain that to the judge and you have a limited number, you could possibly be doing some things like that where you're striking someone because of their race or their gender. If you have a rape case, and you're the defense and your defendant is a client is the one who's accused of rape, you're not going to want to have a bunch of women on your jury, because you're like, they're going to be hard on my client who is accused of raping a woman. So but it's hard to tell, but if there's any kind of suspicion that that's what's happening, then that attorney can get in trouble for doing that, because it's not supposed to be based on those things. All right, so we're going to look at some more information, because you guys will be doing a simulated voir dire process. So hopefully there's no questions, and that cleared up all the questions that I got from the pre-assessment.